We are present at this time in case 10CR 000046. This case is captioned State of Ohio versus Robbie McClure. We are here for a hearing on the defendant's application to expunge the record of arrest and conviction in this matter. The court received this motion. When I received it, I referred it to the probation department so they could prepare a report for me. That has been done. I've had a chance to review that. And we're here for the hearing. Defendant's here in court. You are Ms. McClure?
Yes.
And sir, you are.
Sir, my name is James Levin.
Okay, I thought so, but it has Pinckney on here. I go, I've met you before.
Yes, you have.
All right, so Mr. Levin is here for the defendant. The state of Ohio is represented by Assistant Prosecuting Attorney Fonche. So let me hear from Mr. Levin first. Then, what, if anything, would you like to say on behalf of your request at this time?
Thank you, Judge. I'm here on behalf of Ms. McClure. She's a woman now 61 years old. As indicated in the motion, this is a case that's originated in 2010, approaching its 15th anniversary. She has, this is the only felony on her record. She does have a history of some misdemeanors.
It's only felony in Ohio. I mean, she's just got multiple felonies in Chicago, I think, or wasn't it in Illinois?
Illinois, Your Honor.
Yeah.
2.
What's that?
I know nothing about that in Chicago.
Did you live in Chicago?
No. I've never been to the penitentiary or anything in Chicago.
Well, maybe it was Illinois. Let me look it up.
Illinois.
Hang on one second. Did you see the report at all, Mr. Levin?
No, I have not seen the report. Sorry.
Would you like me to have?
Yeah, thank you.
Let's take a moment to look that over, and I'll come back on in a few minutes.
Thank you very much, Your Honor.
All rise.
All right, we're back on the record at this time. Mr. Levin has had an opportunity to read the report prepared by the probation department. So Mr. Levin, I'll let you continue at this time.
Thank you, Your Honor. Appreciate the opportunity to review the probation report. With respect to her other felony charge in Chicago of 2001, obviously preceding the case before you now, the indication is that the disposition is unknown. Our position is that the defendant went through a probationary diversion-like program and that matter had been, in fact...
All right, well, there's a felony in 1996. There's another felony in 1996 also. November 6, 96, retail theft, class 3 felony, 18 months probation. Then 20 days later, Oak Lawn Police Department, forgery, class 3 felony, theft. I don't know what this stuff, theft, mislaid property, class Z, whatever that means. She got 6 months imprisonment in jail, 24 months special probation. Those are both in 96. So I say the one you're talking about, that says disposition unknown, but there were 2 others, 5.
Before that, yes, in the 90s. Well, as the court is aware, that is over approximately 30 years ago. Since that time, since 2022, this defendant has been misconduct-free and sober. I have a letter to present to the court that I just received. I did furnish a copy to the state from Life Solutions South, indicating that she has been a client there since July 26, 2022, that within a year she'd be actively participating in the second phase of the program, aftercare, and has faithfully attended for a year. She's involved with several activities of merit, attending church on a regular basis, and is a trusted servant leader with her AA home group. That on several occasions she has assisted her fellow participants with advice on maintaining sobriety, that she is a valued client and a positive influence on other people who are in early recovery. So I do concede, and it's my fault for not having checked with the probation department in advance. I will learn from this experience. But since 2022, for over 2 years now, she has been sober. She's working in a program. I would respectfully submit that shows significant rehabilitation from a life of addiction. She's presently fully employed. I should say she's part-time employed, working 20 hours a week with KLM, which is a cleaning service company. She cleans a school on the east side of Cleveland. E-Prep, located at 36th and Superior. She herself wants to go back to school, and she's been told by her present employer that because she does work in a school with children around, that she's in a position where she has to have this cleared up, or she'd be potentially losing her job. She's, since 22, her sobriety, she's become a licensed minister, where she works as such at the Lakeside Bible Church at 125th and St. Clair? Euclid, in Cleveland. I think this is about people kind of learning from and departing from the worst mistakes of their life. She had a long stretch here from the 90s through the teens of criminal activity. I recognize that. The state legislature provides that if people have showing that they're able to rehabilitate themselves and depart from a course of misconduct, that they can get these matters sealed and or expunged. And I think she's a candidate within the purview of what the legislature's intent was, is to allow people a second chance. And I ask the court to grant the motion. Thank you. The defendant would like to address the court.
I'm going to give her an opportunity to. Ms. McClure?
Good afternoon, Your Honor. I know I had made a lot of mistakes as far as, having a real bad drug habit. And after the last time I went to jail, I was done, because I was getting much older and I knew I couldn't do that.
How old are you now?
I'm 61. And I knew I had to change not just my way of life, my way of thinking. Because with all the drugs, my mindset was so distorted. I didn't know the real meaning of having a right thought. So, I know I made a lot of mistakes. I'm trying to do better in my life. My children are grown now, and I'm trying to be a better, positive person for my children and for myself, and to help other people that was in the position that I was in with the drugs. I just wanted to do better and to be a better person. To be better today than I was yesterday. Thank you.
So what, your attorney said you want to go back to school.
Yeah.
What do you want to go back to school
I'm
for?
going to go back to school to get my CDCA license,
Which
a
is
drug
what?
counselor.
What is that?
A drug counselor.
Oh. What kind of schooling does that require?
You have to take classes, you have to learn the terminology, the reason, the mental part of it,
How long is that program,
It's like 2 years. So you have to have all the aspects of not just the addiction, the mental part, the depression part, and all that. You have to.
Where would you be taking these classes?
I was thinking about going to Cuyotta.
Tri-C?
Yeah, Tri-C.
They offer that there?
Yes, they do.
Who were you told by, or what were you told in regards to this conviction being a block for that?
But far as school, I know it's hard, if you have like a felony to get in school or to get grants for school and stuff like that. And, my son and my children had been in school, but they don't have any kind of records or anything like that. And my son was telling me, you have to get your record together. Even though you made all your mistakes, you're never too old to go back to school. And if that's what you want to do, you have to be ready to go through all the process you have to go to in order for you to go to school. So this is what I'm trying to do, trying to straighten out all the damage that I have done in all my years.
Well, this is your only felony in Ohio, and it's your only felony in the last almost 30 years, it looks like. And those I know we stopped, we were talking about those felonies back in '96. I really don't care about those. I don't care about them, but what concerns me more, if you want to be quite frank, is the 5 convictions you had since you got out of prison. Now, they were all misdemeanors, and they're all theft offenses, so they weren't felonies. But what was going on there?
I mean, I was still back and forth, not focusing, still, in and out, using here and there, and then it had got to the point it was on a regular basis. So I was just doing stuff that I needed to do so I can continue to do the drugs.
So you were using during this whole time? During this time when these theft convictions were going on?
Yeah.
And when did you stop using?
In 21.
The last
That was
conviction
the
was
last time I
that was
went to
July of
jail.
21.
Yeah. And I've been sober since October. the
October of
3rd.
21.
Yeah.
So what's that? 3.5 years almost.
Yes. And I've been in this program at Life Solution, and I think it's for like 3 years. I think I got like a year and a half there.
You got what?
A year and a half in that program. So it's a 3-year program.
Okay.
Because I did the IOP, and now I'm doing the aftercare.
All right. Is there anything else you'd like me to know?
No, that's it.
All right, thank you.
Thank you.
Mr. Levin, anything else on behalf of Ms. McCoy?
No, Your Honor.
For the state of Ohio? Mr. Bonci?
Yes, thank you, Your Honor. I'm in for Ms. Taylor Linden. She has asked me to lodge an objection. Defendant does apparently meet the technical requirements for expungement. We would question rehabilitation for many of the reasons that Your Honor has actually set out himself. These show a pattern before and after the case that we're dealing with today, a pattern of crimes of dishonesty for some 12 cycles in Illinois, some 12 cycles in Ohio, a continuous pattern. There's also a failure to pay supervision fees. It's a small amount, but it does not strike us that the defendant is doing everything she can to demonstrate rehabilitation. The motion that we received does not demonstrate, but does not really, it just bare offers of, or statements, no really offers of proof until what we heard today, more statements, Your Honor. We would suggest that the defendant reapply at a later date, perhaps after showing more things that have been done in order to actually show rehabilitation, Your Honor. The state does have an interest in maintaining the record until the defendant shows such rehabilitation. Thank you, Your Honor.
Thank you. Well, there is a $60 outstanding.
I didn't even know
I'm sure you didn't. I'm not. But you paid all your court costs, but the $60 is owed for supervision fees. They would pay that to you guys, right? And then your sentence is completely, is completed in full. I'm going to take the matter under advisement. Why don't you talk to Ms. Randazzo here about those fees. I'll take it under advisement, and then I'll issue my ruling.
Thank you, Judge.
Thank you.
You're welcome. Anything else? All right, thank you all.
All rise.